The Prime Minister says there's already been a full airing of the SNC-Lavalin controversy, but Jody Wilson-Raybould says the case isn't closed. Today, she wrote this letter to the Justice Committee saying, quote, "I also have relevant facts and evidence in my possession that further clarify statements I made and elucidate the accuracy and nature of statements by witnesses in testimony that came after my committee appearance." So what will the Justice Committee do with that new information? Quebec Liberal MP Anthony Housefather chairs the House Justice Committee, and he joins me now via Skype from Montreal. Hi, Mr. Housefather. Nice to see you again. Thank you for your time.
Hi, Vashi.
So Ms. Wilson-Raybould wrote to you saying since she won't be recalled to, quote, complete her testimony, she'll send along emails, texts, and other evidence to, and these are her words, clarify the accuracy of testimony from witnesses who followed her appearance. So that would be Mr. Butts, Mr. Warnick, and Ms. Drouin. Why doesn't your committee just actually let her complete her testimony?
Well, I mean, I think the answer is the fact that she had 38 minutes for an opening statement when we usually grant 10, and she had about 4 hours before the committee. And she even was saying at the end that the questions were becoming repetitive. The committee has other matters that we've delayed for the last 5 weeks. We're supposed to be doing a study on HIV criminalization. We're supposed to be doing a study now on online hate. And we want to also make sure we do those before we wrap up when the parliamentary session ends. So I think that members had felt that we had allowed Canadians to hear from the principals. We'd given them quite a bit of time, 13 hours of testimony. And the committee, by majority, was ready to move on. But that is not to say that we ever told witnesses that they couldn't complete their oral testimony by written submissions. And we're certainly happy, I am for sure, to receive anything that Ms. Wilson-Raybould wants to send.
So haven't you prejudiced yourself, though, a little bit by saying that you feel that there has already been a full airing of everything you need to know? I mean, if this new evidence brings to light something that changes the nature of this story, are you actually open to looking at that?
Well, I mean, look at the fact that the Conservatives have now asked for the Prime Minister to resign. The Conservatives have asked for the RCMP to investigate. They've made all kinds of allegations. So I don't think it would be fair to say that when you have partisan people dealing with a situation, that anybody has a totally open mind. That's why when you have a court, you have a judge and you have a jury who don't know the people involved and who have no stake in what happens.
Yeah, but in this case, with respect, you know, that's a question for me to ask the Conservatives when they're about to listen to testimony. I mean, she has written specifically to you saying she wants to offer more evidence, and you've just finished telling me that you've heard all you need to hear.
I don't think I said that. I think that the committee had determined that the committee did not need to hear more oral testimony.
Well, the Liberal members of the committee determined.
The majority on the committee determined that they didn't need to hear more oral testimony, but that is not to say that witnesses don't have the right to submit written submissions that will complement or supplement their oral testimony. And I will welcome to receive what Ms. Wilson-Raybould has to send me. And if what she sends me somehow changes my mind about that, well, then so be it. Right now, what I'm saying is that we're certainly happy to receive it. And I think Canadians will get a chance to see what Ms. Wilson-Raybould sends, because my intention is that when we receive her testimony, we'll follow the normal practice where it'll be translated, sent to the members of the committee for their review, and then made available to the public online. And then people can judge for themselves in the same way they were able to judge for themselves during the 13 hours of testimony as to the veracity of the witnesses.
So just to be clear, you're promising to make it all public?
Well, again, what I'm saying is that I would make it public. That's certainly my recommendation to the committee. That is our standard practice. And so my belief is that it will be public, yes.
Will the committee have to vote on whether or not it's public?
No, I think because our standard practice is that it would be public, the committee would actually have to vote to make it not public, I think.
Okay.
Because I think it's my role to be master of that information. And when the information comes in, to submit it to the standard practice. So I think they would have to vote the opposite, and I don't think any member of the committee would do that.
And just to be clear, just so that I know and our viewers know, once you receive that information, I mean, sometimes when a committee conducts a study, there's a document that's produced at the end. Is your committee going to produce that kind of a document here? And is that where this new information or evidence that is presented could end up having an impact?
Well, I think it would have an impact on the public consciousness in the sense that it would be made public, so people can judge it for themselves. As to whether the committee submits some type of a report or a letter, it differs by study or it differs by meeting type. In this case, the committee has not adopted any resolution to do that, so it would be up to the committee if it wanted to do that.
Okay, I'll leave it there. Thank you so much for joining us this evening, Mr. Housefather. Really appreciate your time.
Pleasure anytime.
Both Jody Wilson-Raybould and Jane Philpott say there's more to the SNC-Lavalin story, but they're citing cabinet confidentiality for keeping them from disclosing those details, and in the case of Jody Wilson-Raybould, solicitor-client privilege. So what can the two former ministers legally say? Errol Mendez is a professor of constitutional and international law at the University of Ottawa and president of the International Commission of Jurists in Canada. Hello, Mr. Professor Mendez. I'm sorry, nice to see you again.
Nice to see you too.
I appreciate your time. Let me just get a quick reaction to what we heard from Mr. Housefather there. Is it rare? I mean, I know that you have a lot of experience in Parliament, but is there any way this evidence could, I mean, it sounds like it's just going to be put out there and then it's more for people to decide. There's no actual conclusion that the committee is reaching.
Well, I think the evidence that she's going to produce will have, to some extent, that impact. Now, whether or not the committee produces a report, many committees do produce reports, and they could if they wanted to. But again, it would depend on what the majority of the Liberal MPs want to do in this case. But I think the main focus, I think, from the former Minister of Justice and Attorney General is to present more evidence as to her view that there was inappropriate pressure to counter what in the testimony of the clerk and Mr. Butts was appropriate pressure. So it's the evidence goes to inappropriate pressure as opposed to appropriate pressure.
So
if you understand that.
For sure. So let's talk about how that evidence can be submitted, because that's been the subject of debate, especially over throughout this whole thing, but especially over the last week, because we hear from Jane Philpott through the Maclean's piece that she has more to say. We now hear in this letter that there is more evidence and more that Jody Wilson-Raybould wants to say as well. We had Rob Walsh on the show, former law clerk of the House of Commons, who says they can stand up and under parliamentary privilege in the House or before a committee say whatever they want to say. It won't be easy because it's not procedurally easy to do so, but they can. What do you think?
Well, I think in theory he's right. That parliamentary privilege covers all other types of privilege, and in terms of legal constraints, they could basically say whatever they want to say. However, I think what is being ignored, and this is where I hesitate to disagree with Bob Walsh, who I have a great admiration for, is the fact that I think both with Jane Philpott and with Jody Wilson-Raybould, is that I think they have, if you like, a moral constraint based on their oath as a Privy Councillor. And when you look at that oath, it talks about how it goes way beyond just the legal constraints. It talks about being faithful to the cabinet as a whole. It talks about keeping secret and in principle for life, the secrets obtained as a Privy Councillor. And then you swear on that. So there's an obligation which goes even higher than the legal constraints.
I imagine people listening, though, would think, wasn't that testimony that we heard, detailing so many interactions on the SNC file, was that at all contravening that oath?
Well, no, because there was a waiver given by the Prime Minister. But here's where I think there's a misunderstanding that the areas in which Jane Philpott and the former Minister of Justice wants to talk more about goes beyond the evidence that she wants to produce with this committee. It's based on what she's trying to say was that period between when she was demoted and the time she resigned. And I think both of them have want to talk about how much was that interaction influenced by the desire to have a DPA and to have, if you like, a shuffle and bring in a new Minister of Justice.
So if you were advising them as a lawyer, this is what I've always been curious about, because that like you're right, they keep saying it's that period after which Jody Wilson-Raybould left the position as Attorney General, and the big question is why did you tell the Prime Minister you resigned, or why did you resign? And that all occurred, of course, after that shuffle.
Right.
Would you be advising her not to talk on that period as well? Is that how you understand the order in council?
Well, until she gets a waiver, that's right. Not just based on the legal constraints, but I think on the moral constraints, based on the oath, if that's what she's basing it on. But frankly, my advice both to her and Jane Philpott and the Prime Minister is to say, this will come out eventually anyway. So please let it come out, but also then put in place a way to sort of bring this whole issue to a solution, such as getting them involved, for example, to make sure this sort of thing never happens again. New Zealand has tried to do that by different means, by putting in place precise guidelines on how these constitutional conventions are in place, we have to do that.
So do you mean that you think that the waiver should be extended regardless of the debate, but if the waiver was just extended then?
Yeah, I think because ultimately this may come out anyway. And so the goal, I think, not just for the party but for the country, is to find ways to make this a permanent solution so this will never happen again.
All right, I'll leave it there. Thank you, Professor Mendez. I really appreciate your insight and time this afternoon.
You're very
Evening,
welcome.
I mean.
You're very welcome.